Good afternoon, everybody. My name is Maggie Kinnear. I'm an attorney with the Atlanta Legal Aid Society. I work in the downtown office in the general law unit. A few things before we get started today on talking about evictions. First, I do want to let you know we are having some weather here in Atlanta, so I apologize if it gets noisy outside my office. Hopefully it's calmed down a little bit. But if you hear some thunder or some rain, it's just the day we're having today. Atlanta Legal Aid provides civil legal services to low-income individuals and families in the Atlanta metropolitan area. We handle a variety of cases, including domestic relations, consumer, various types of benefits, and our topic for today, which is housing, specifically evictions. This is a general presentation about Georgia law, and it may not directly apply to the facts of your case. Every case is different. For specific legal advice, please contact an attorney for individual consultation. This presentation does not create an attorney-client relationship. This presentation is Georgia specific and meant for people who are tenants in the state of Georgia. If you are in another state or territory, welcome. We're glad you're here. But please make sure you contact your local legal aid or legal services organization with any questions that you may have about the rules and or process for evictions in your state or territory. If you have questions during the presentation today, please ask them in the chat section or ask your question on Facebook. Someone is monitoring that and will make sure that your question is addressed. Please keep your questions general. We are recording this and broadcasting it. And also the comments on Facebook are public for anyone who's on our page. So if you have a specific question and you need to go into details about something that's going on with you, please call legal aid for a private consultation so that you can talk with someone in depth about what's going on with your case. We will also be posting information such as links to rent assistance programs in the chat throughout this presentation. So just be aware of that. I'll also try to make sure that you have a chance to write down that information when we get to that slide. All right, here we go. All right, before we get into the evictions, a few things that you need to know about Georgia law as a tenant. Always pay your rent in full and on time every month. Georgia law does not allow tenants to withhold their rent, even if the landlord has failed to make repairs. Those are considered separate obligations. If you withhold your rent, you are risking the possibility of an eviction being filed. So please reach out to an attorney and talk about your options with regard to repair issues. We'll talk about them a little bit today, but we're not going to go into great detail about that because we're focused more on the eviction process. But please make sure when you pay your rent that you don't ever pay in cash, that you keep receipts so you have a paper trail showing that you paid your rent. And if the rent is refused or returned to you, make sure that you save it so that you have proof that you tried to tender your rent on time. Also, in addition, just make sure, if there are repair issues, anything else that's going on, that you put everything in writing to your landlord, and then you keep a copy of it. You just got to make sure that you're protecting yourself and that you have a paper trail of when you notified the landlord about an issue and sort of what their response was. Documenting it, putting it in writing can include things like emails and text messages. Just make sure that they're clear, especially with a text message. I know we tend to sort of talk in text speak, I guess. Just make sure that it's clear what you're saying, that, dear landlord, there's something that needs to be fixed here. Please come and fix it. Because we do get this question a lot, I will go ahead and answer it now. Georgia is a one-party consent state for recording conversations. If you are having a conversation with someone, you can record it. As long as you know it's being recorded, you're the one party. You can't record a conversation that someone else is having. You have to be a party to the conversation. But you can record a conversation that you're having, including a conversation you're having with your landlord or someone else. Just make sure you remember that you are being recorded too. So just FYI. All right. In Georgia, Landlords are required by Georgia law to go through a court process in order to lawfully evict a tenant. Georgia does not allow landlords to put a tenant's things out, to change the locks, to disconnect utilities, anything like that. They have to go through a court process, get a court order allowing them to evict the tenant, and then they have to execute the writ of possession and have the marshals come out to actually evict the tenant. And we'll go through all of that later in the presentation. Just want to let you know up front. It is a required process under Georgia law. Once an eviction is filed, please consider the court to be another party to the case and always make sure that they are informed of what is going on. Do not necessarily rely on your landlord to keep the court updated. You can go ahead and file things and say, here's an update. The rent assistance has been paid and here's proof of that. So the court knows what's going on at all times. If you and your landlord settle a case between yourselves, that's wonderful. Just make sure that you are providing information about that to the court so that you don't inadvertently end up having an eviction happen without you knowing what's going on because the court isn't aware of what's going on. There are currently no more moratoriums for evictions. There are rent assistance programs. As I said, we'll be providing those links to you. Atlanta Legal Aid, unfortunately, does not have any rent assistance itself. We do offer legal advice and representation to tenants facing eviction. If you've applied for rent assistance, make sure that you are keeping in contact with the rent assistance agency. If they have a portal, which the Georgia Rental Assistance Program does, and maybe some others do as well, you can make sure you're monitoring what's going on in the portal, upload any documents they need, so that you know what's going on with your rent assistance application and can follow up with them if there's a need to do so. Okay, an eviction case may be filed for any alleged breach of the lease agreement or terms of the tenancy. In Georgia, you don't necessarily have to have a written lease to have a tenancy. You just have to be using property that someone else has given you permission to use. Most of the time, an eviction is filed for non-payment of rent. I think probably the vast majority of cases are for non-payment, but those breaches can include things like conduct that happened on the property by a tenant or a tenant's guest, having people live with you who aren't on the lease, things like that. The only prerequisite under Georgia law before a landlord files an eviction action is that they have to demand possession of the property. And that under Georgia law is as simple as a landlord saying, get out now. They don't have to give you a 30-day notice at that point. They don't have to do anything other than demand that you vacate the property. Once they've done that, they can go ahead and file the eviction action. A lot of times, like a landlord will say, you need to do what's called like quit or pay rent, right? We'll give you 3 days to pay your rent. If you don't, we're going to file an eviction. After that third day, because they've given you that third day, they can go file. But a landlord could walk up to you and say, you owe rent. You don't pay it right now. I'm going to go file an eviction. They've demanded possession and they can move forward with an eviction action. Evictions are an expedited process. That's another reason why if you are having repair issues in your home that the landlord isn't addressing, I strongly advise against withholding rent. Yes, you can raise those as counterclaims, but the eviction process moves pretty quickly and it's not always the best forum for raising those issues because of how fast it moves. This is an example of the Fulton County dispossessory warrant or eviction warrant. Those terms can be used interchangeably. Other counties have slight variations, but I think they all kind of look about the same. My practice is primarily in Fulton County, so that's why I uploaded this. But this is kind of what you will get if an eviction warrant is filed against you. It can be served. It has to be served by either a marshal or a process server. The court has to approve process servers in advance, and most courts will have a list of approved process servers in case there's a question about the person who served you. You can be served personally, which basically means they hand it to you. You can be served notoriously, which means that they have to give it to a person of what's called suitable age who lives in your household. That could include a teenager, but should not include a child, a younger child. That said, if you're kind of expecting that something might happen, please make sure that anyone in your household, including maybe people who are visiting or tend to visit frequently, that they know to give you something if someone hands them something, or if they find it on the door. Because the most common way that eviction cases are served, at least around the Atlanta area, is by tack and mail. That basically means that the marshal or process server comes out. They're supposed to knock on the door first, and if no one answers, they tack a copy of the eviction warrant to the door, and then they mail a copy to you that same day. So if something is on the door when you get home and it's an eviction warrant, that was valid service. Do make sure that you check the mail for the mailed copy, and keep the envelope if it was mailed on a different day, if the postmark is a different day than the date that it was tacked to the door, because you can raise improper service as an issue when you file your answer. If you are served by tack and mail and no answer is filed, then the landlord is entitled to an immediate writ of possession, but they will not get a money judgment. That is important in cases where maybe you're moving and you're going to be moving out within the next few days and you're served by tack and mail. In that situation, you may not want to file an answer. If you have questions, if something like that has come up and you have questions about it, please reach out to an attorney to talk about your options. Otherwise, please make sure you file an answer. If you're going to be in the property for a little while longer, if you were served personally, please make sure you file an answer. Only when it's tack and mail and you're going to be moving out anyway within the next few days, you may want to consider not filing an answer, because your landlord is only going to get possession, which you're giving back to them anyway, but they won't get a money judgment at that point. On the eviction warrant, on the vast majority of them, sort of towards the bottom where it says constable's entry of service, that's where you're going to find where they've written in the date of service and the answer deadline. The answer has to be filed by that deadline, which is 7 days from the date that you were served. You might have a little more time if it's like that day is a holiday or a weekend day, but that is your deadline. And I highly advise you to make sure you file the answer by that deadline. Please don't ignore if you get served with an eviction warrant. Up there under the summons section is the information about where you need to go to file your answer. It's got the courthouse address on it. It will let you know if you can file the answer online. In Fulton County, you can file online, or you can go in person. If you're going to file online, please make sure that you try to do that maybe the day before the answer deadline. So if there's a technical issue of some sort, you still have time to go in person to file the answer the next day. That deadline is very hard and fast, and you want to make sure that you get your answer filed timely so that you're preserving your rights. If you have questions about like where to go or anything like that, you can also go to the court's website. If you just Google Magistrate Court of Fulton County or Magistrate Court of DeKalb County, whatever county you're in, whatever court is on the top of the page, there should be information there about the dispossessory process as well, and possibly a link to the online system for filing the answer. All right. As I said, when you're served with an eviction warrant, the answer is due within 7 days of the date of service. That's a very hard and fast deadline. So like I said, please make sure you file an answer within those 7 days. You don't have to wait till the last day. You can file it the next day if you want, but you do have that 7-day period to file an answer. The named defendant needs to be the one to file the answer. That's usually the person who signed the lease. usually the person living in the household, but just in case, the named defendant is the one that needs to file an answer. If there's more than one named defendant, you either all need to file an answer, you can file one answer that you all sign, or you can each file your own answer. It's up to you. But just make sure that everyone who is named as a defendant files an answer. If the named defendant has left, if they're no longer in the household, and maybe you were there and you're on the lease as a household member, or some other situation like that, you can go down as an occupant and file an answer, and at least make sure that you get some additional time and maybe an opportunity to try to resolve things with the landlord. In the answer, and we'll get into this a little bit more in a minute, you can raise any defenses that you have to the claims that the landlord brought, and you can raise any counterclaims that you may have against your landlord. So that would be the place where you could raise the issue of repairs that haven't been made, things like that. As I said before, always make sure that you file an answer. If no answer is filed, then a default judgment is automatically entered against the tenant, and there's no way to appeal that. And it is very difficult to get it reopened. You really have to show compelling circumstances, and you have to explain those circumstances to the court when you file a late answer. If you are in a position where you're filing a late answer, please make sure that you, in addition to listing your defenses and counterclaims, give the court some explanation for why the answer was late. If there were compelling circumstances, the court has the discretion to reopen the default judgment, but in the vast majority of cases, if you miss that deadline, your landlord has a default judgment, they can evict you immediately. And if you were served with personal service, they also do have a money judgment against you. So like I said, please make sure you file an answer. Even if you get served with the warrant and the landlord says, oh, don't worry about it, I'm going to work with you. That's great. I hope that they do, but please still make sure you file an answer so that the court knows what's going on, and that you are protecting your rights to have the whole process and not be evicted, even though you think maybe you're working things out. This is the answer form that Fulton County uses. Other counties have similar forms. Whatever county you're in, the court should have this there for you to use. In Fulton, if you go online, there's basically an electronic version of this form there for you to fill out, but there are copies of this form down at the courthouse that you can use to file your answer. If you go, whether you go in person or online, make sure that you've got the eviction warrant with you so that you can refer to it. It has important information on it, like the case number, but also, if there are allegations that you want to specifically address, you can do that. These are just notice pleadings. You don't have to go into detail when you file the answer, and you also don't have to attach your evidence when you file the answer. You just have to basically notify the court. Maybe your landlord filed an eviction for non-payment of rent and you tried to pay it, so you can let the court know, I tried to pay my rent and my landlord wouldn't take it. Maybe they filed, for alleging some kind of conduct issue. You can say, like, they terminated my lease without a valid reason. I dispute that they have the right to evict me. Those are both things that you can just check off on. You don't have to get into detail there in the answer. You can do that at the hearing. So, like I said, this section up here at the top is where you would list your defenses. Just make sure that you check things off that apply. If you're not sure, you can go ahead and check it off. You think maybe it might apply, go ahead and check it. You can always sort that out at the hearing later on. But just it's better to check things off and preserve that defense. So some common defenses that are raised, and these are all things that have kind of corresponding places that you can check off, but you can also write in something if you're not quite sure what applies. The first is no landlord-tenant relationship. In order to evict someone, there has to be a landlord and a tenant. This does apply in a lot of housing situations, but it doesn't apply to things like roommates, domestic partners, things like that. Now, if you are in a rental property and there's maybe new management takes over, you're in a house and it's sold, and a new homeowner takes over, those are your landlords. You may not have initially had a lease with them. You may not have been working with them until just recently, but they've stepped into the role. They've taken over the property, subject to your tenancy. So even if you're in a house and the person who owned the house has sold it to a new homeowner, that person still has to honor, whatever part is left in your lease, or has to give you proper notice. If you're living there without a lease, like they have to come in and kind of, they take it subject to your tenancy, basically. If you are in a property that's sold at foreclosure, there's a federal law called the Protecting Tenants at Foreclosure Act. It does require the new owner in most situations to provide you with 90 days notice, and it has some other protections. That applies to tenants. If you were the prior homeowner, that unfortunately does not protect you. Another common defense is that service was improper. Like I said, if it's tack and mail service and it's tacked on Friday but not mailed until Monday, you can raise that in your answer. You do need to write it in to say like this wasn't served properly, and then bring the evidence of that when you go to court. No demand or improper notice. As I said, under Georgia law, the only thing that a landlord has to do prior to filing an eviction is demand possession of the property. But if they didn't do that, you can raise that as a defense in your eviction case. If you are in subsidized housing, there are additional notice requirements. And if they didn't meet those requirements, you can let the court know that they didn't properly, they didn't give you the proper notice prior to filing the eviction, or they didn't go through the grievance process that they were required to. That does happen sometimes. Obviously, no breach of the lease agreement. Like I said, my landlord doesn't have a valid reason to terminate my lease. You're just disputing their claims. With rent, there are a few defenses that you can raise. One is I tried to pay the rent and the landlord wouldn't take it. You can also raise the issue of I've been making partial payments, including one this month, or in some cases we'll have a situation where like the lease may say that the rent is due by the 5th day of the month, but the way the tenancy has worked from pretty much the beginning, the tenant has made a payment beginning of the month and the middle of the month, based on when they get paid. And they've been going like that the entire time. And suddenly the landlord says, no, you have to, I'm filing the eviction because you're making a partial payment at the beginning of the month. If those irregular payments have been a pattern, there's an argument that the parties change the terms of the tenancy. The landlord at the very least has to give the tenant notice that they're going to change it back to the original terms before they can file an eviction. It may be possible in some cases where payments have been made, but maybe not in full, where the landlord might be entitled to a judgment that says that they're owed money, but because of how they've been accepting the rent, they're not entitled to evict the tenant. But all of that, it's really key that you have proof of the payments that you have been making to kind of show that pattern or show that partial payments have been made. It's really going to come down to timing and what documentation you have. So make sure that you're saving, even if everything's seems to be going well, make sure you're saving your rent receipts and your proof of payments, so you have them if you need them. Waiver of grounds to terminate the lease basically just means there's case law in Georgia that says if the landlord knew or should have known about something, that could have been grounds to terminate the lease, but waits several months before they move to evict the tenant, they've waived the right to use those as grounds to terminate the lease. And finally, bankruptcy. Bankruptcy can be a little bit tricky. Most of the time when you file bankruptcy, and especially if you include the landlord as a creditor, there is an automatic stay. Not always, depending on the circumstances, but there usually is. That stay, if you notify the court that the bankruptcy has been filed, should apply to the case. But that doesn't necessarily mean that the eviction case is over. If I file bankruptcy today on July 21st, I can include rent that may be owed to my landlord through July. But August is coming, and that bankruptcy doesn't include August rent. So if bankruptcy is something that you're looking at as an option, you really need to make sure that you're talking with your bankruptcy attorney, and you may also want to talk to a housing attorney to make sure that it protects you, but that also that you know what you need to do going forward, so that you don't end up in a situation where August rent isn't paid and the landlord moves to have the stay lifted so that they can proceed with the eviction. Then this section here on the answer form is where you can include your counterclaims if you have them against the landlord. Any kind of claim really that you have could be put there, but the vast majority of them are related to there's the landlord's failure to maintain and repair the property. As I said at the beginning, Georgia law does not allow tenants to withhold their rent because they consider that a separate obligation from the landlord's obligation to maintain and repair the property. But that is the landlord's obligation. Really, the only exception is obviously if the tenant, like if you're throwing a ball around and you break a window, you might have to fix the window, or at least reimburse the landlord for it. But otherwise, you know, stuff happens. Air conditioning units break down, leaks happen, things like that. All of that is the landlord's responsibility to maintain and repair the property. And if they don't, and it's impacted you in some way, it's damaged your property, you can't use one of the bedrooms. So maybe you have a 3-bedroom apartment, but really it's a 2-bedroom apartment because the back bedroom is full of mold, things like that. You can file a counterclaim and request damages from the landlord. If they, if the damages you're entitled to are more than the rent that's owed, then you may be able to defeat the claim for possession. That can be really hard to do, especially, as I said, because this is an expedited process. So again, if you're having repair issues, please don't withhold your rent. Contact an attorney so you can talk through what options you may have to try to deal with the repair issues. Any other breach of the lease agreement can be raised as a counterclaim. The landlord is just as bound to the lease as the tenant. It's a contract between the two parties. They're both bound to it. An improper eviction. If the landlord, prior to filing the eviction action, tried to do something to illegally evict the tenant, disconnect the utilities, lock them out, put their things out, and there were damages related to that, you can raise that as a counterclaim in an eviction case. Any kind of interference with the tenant's right to use and enjoy the property. The landlord may be the homeowner, but they've given the tenant the right to use the property, and they can't interfere with that. They do have some rights to be on the property, especially when it comes to things like making repairs, but they can't just sort of show up and be on the property just because they want to. It's yes, they are the homeowner, but they've given the tenant the right to use it, and they can't be interfering with that. Other counterclaims that you can raise are violations of fair housing laws. There's federal fair housing law, Georgia law that follows it very similar. That discrimination based on race, gender, ethnicity, religion, things like that. Okay. Once you file an answer, the court will schedule the case for a hearing. Usually pre-pandemic, that was usually within about a week or two of when the answer was filed. Right now, it's a little hard to say. Some courts still have backlogs that they're working through, so it may be a little bit longer before the hearing is scheduled. But the court will schedule the hearing and they'll send you a notice of the date and time of the hearing. Right now in Fulton County, they are still doing hybrid hearings, so you can participate in person or through Zoom. Each county is doing it differently. A lot of them are entirely in person. I think Fulton is working towards being entirely in person, but just pay attention to the notice. It will tell you where you need to go, whether you can do it online or you have to go in person. And please make sure that you are on time for court. If you have like a 9 a.m. court hearing, I know it's early in the morning, but please make sure that you're there on time. Try to get there 8:30 to 8:45 so that you have a cushion if there's a parking issue or wherever, because they're going to call the calendar, and if you're not there, that could be a problem. And we'll talk about that in a minute. In most counties, they will give you the option of going to mediation. That could be kind of formal, where you and the landlord go and you have a mediator with you and you try to see if you can work something out. In other counties, it's going to be informal. They're just going to send you into the hallway to talk. You can work out an agreement with your landlord at that point. You can work out an agreement with your landlord before court. Even if you do that, please make sure that you go to the hearing so that the court knows what's going on and that you all have come to an agreement. Make sure you're both there to let the court know what's going on. If you sign an agreement in mediation, it will be binding. It will be the resolution of the case. It'll be binding on both parties. There's really no way to go back and change it. So make sure before you sign it that it includes all the terms that you expect it to include. Maybe the landlord and you talked about, the landlord making repairs to things, but if it's not written in the agreement, then it's not part of the agreement. So make sure, yes, there's a payment plan for you to make, to pay off the back balance, but make sure it also says something about the landlord making those repairs according to what they said when you guys were talking. And also make sure that you can live with it. If you have a payment plan in place for you and you can afford those payments, that's great. Maybe once those payments are made, the case will get dismissed. You'll be able to stay in the unit. That's great. But if those payments are more than you can afford, then signing the agreement actually really hasn't helped you, because there's really not anything that you can do at that point, except unfortunately try to move out before you end up getting evicted. Because if the agreement isn't, if the terms of the agreement aren't met, most likely the landlord will be allowed to get a writ of possession to evict you, and you won't be able to go back for a hearing or anything about that. If the case is not settled in mediation, there will be a hearing. Both sides will get a chance to talk to the judge. You can present documents, you can present witnesses. If you want to present a witness, they have to be there in person or on the Zoom if you're allowed to do Zoom court. You can't just bring a notarized statement from someone. They have to be there so that the other side can also question them about what they witnessed. Judge usually makes a decision there in court. They don't have to. They could issue a decision the next day or the day after, but usually in eviction cases, they'll make a decision there on the bench. If they decide against the tenant, a writ of possession will issue in 7 days if there's a judgment against the tenant. If the judge makes a decision, there is the possibility of filing an appeal, and we can talk about that in just a minute. As I said before, please make sure you're on time for court. If you're not, if the tenant does not appear for the court hearing, an automatic default judgment will be entered against them. That cannot be appealed, and just like when missing the answer deadline, it is really difficult to have that reopened. There really have to be very compelling circumstances for it. If you submit a request for a continuance prior to the court case, prior to the hearing, Do not assume that it is going to be granted. You can always ask for one. You can ask for one at the hearing. The court has discretion whether or not to grant it. So don't just submit the request for a continuance and then assume everything is fine. The case is going to be rescheduled. You do need to make sure you follow up with the court. If it's not granted, then you do need to be at the court hearing. If the landlord does not appear, the case will be dismissed. If you have brought counterclaims against the landlord, you can let the court know that you'd like to proceed with a hearing on those counterclaims, or you can voluntarily dismiss them. It's up to you which one you want to do. If the judge makes a decision, either party can file an appeal of that decision. If you're in magistrate court, you can file an appeal to state or superior court. You do need to let the court know which one you want to go to. And it's a de novo appeal, which basically means a do-over. So the pleadings will go up to the state court, but you'll have a chance to have a new hearing, present the evidence again in front of another judge. It's basically an all new process. The appeal has to be filed within 7 days of the date of the magistrate court judgment. There is an appeal form in most courts that you can use. Fulton County certainly has one. I think a lot of the other counties do as well. But all you need to do is just write something saying, I want to appeal the magistrate court decision in this case to the state court, and file that in the magistrate court. There are a couple of things, though, to be aware of. The first is that there are costs associated with the appeal. You can ask the court to waive those costs. If the court issues an order, you'll have to fill out like a poverty affidavit, which most courts have forms that they want you to use. If the court grants it, and just make sure that it gets filed, and those appeal costs should be waived. If it's not waived, you need to make sure that you pay them timely, or the appeal will be dismissed for not paying those appeal costs. The other thing to be aware of is under Georgia law, rent must be paid into the registry of the court while the case is on appeal in order for the tenant to remain in possession. So the first thing that has to be paid will be any past due amount of rent that the court finds is owed. That has to be paid by the appeal deadline, which again is 7 days from the date of the court order, which is usually the date of the hearing. So that could be, the 4 months of back rent has to be paid within 7 days. You can still file the appeal, but if that rent isn't paid, the landlord can still ask for possession of the property, even if the legal issues continue on the appeal. The other part of the rent being paid into court is that ongoing rent has to be paid into court. So let's say I file the appeal today on July 21st, I have to pay, let's say, June and July rent today. August, I have to pay August rent into court. Most likely I'll have to pay it by the 5th. So make sure you get a copy of the judgment from the court, because it will have a section in it that will sort of lay out what amounts need to be paid and when. As long as the tenant is paying the rent into the registry of the court while the case is on appeal, they can remain in possession until the appeal is heard. But if the rent is not paid, the landlord can ask the court for a writ of possession to have the tenant evicted, even if the appeal continues. The landlord, if no appeal is filed, or if an appeal is filed but the rent isn't paid, the landlord is required to get a writ of possession, which is another form the court has. Have the court agree that they are entitled to evict the tenant, and then they coordinate with the marshals to come out and lawfully evict the tenant. So, like in a case where, let's say, an agreement is signed in mediation, there are payments that have to be made by particular times. If the payment isn't made, the landlord can go down, apply for the writ of possession, and say the tenant didn't make this payment, and the writ of possession will be processed. There won't be a hearing about it. So make sure if you're making payments that you're keeping good records of that. And if you hopefully, once all the payments are made, you can just file something with the court saying judgment's been satisfied, everything's been paid. But do make sure that you're keeping your records, and know that if a payment is missed, it is possible that a writ of possession could issue. There's usually no way to know when the marshals will come out, and the eviction will take place. They don't normally tell people in advance. In some counties, they have been giving people a couple days notice, just because the court has had a backlog, the marshals have also had a backlog. So there is some time sometimes between when the writ issued and when it's being executed. And so sometimes they will give people a couple days heads up. They're not required by law to do that. So if you have reason to believe that a writ of possession might issue, I strongly recommend that you secure your possessions, especially any medications, any important documents, anything that's of value to you, just to make sure that it's not lost in an eviction. And finally, this is some of the various rent assistance programs in Georgia, and in the counties. Like I said, if you've applied for rent assistance, please make sure that you're following up with the agency that you applied with, that you're providing all of the required documents, and that you're keeping records related to any payments that are made. So if there is a question about what was paid and when, you have all of that information. I'm going to leave this up for a little while and kind of just open it up for questions, if we've had any as we've gone along.
Hey Maggie, how are you? Thank you. Great presentation.
Thank you.
A couple of questions. Well, one, someone asked if they could use this video or see it after the presentation, and I answered this in the chat, but just for everybody listening, this will stay up on our Facebook page. You're welcome to post the video to, if you have a page, you can do it that way, or it'll be on our YouTube channel within the next week. So there's lots of ways to get this information. This video won't go away after this presentation. Also, we have a question: how can I get an eviction expunged from my record?
Yeah, we get that a lot these days, and unfortunately, it's not an easy thing to do, and it is not something that's granted just kind of as a matter of course. It is somewhat rare to be able to do it, but you can file a request with the court asking that they seal the record. You have to show compelling circumstances beyond just that you are having trouble finding housing generally. There is considered like a public interest in court records, most court records, not all of them, but most court records. So you would need to show, maybe it should never have been filed, maybe everything has been resolved, and it's impacting your ability to get housing. And then the court will have a hearing about the matter and kind of consider what's going on and make a decision about whether or not they can seal the record. If you want to talk further about that, you are welcome to give us a call so we can talk about your specific situation.
Awesome. The numbers for Atlanta Legal Aid and also for Georgia Legal Services, if you live outside of our service area, are in the chat as well. Someone else is wondering if they have an eviction filed, but they can't afford the rent, should they still file an answer?
Yes. At the very least, file the answer. You can let the court know what's going on. If you've got counterclaims, maybe you can raise those as well. And then you're protecting your rights, and you're also buying yourself a little bit of time to hopefully get the rent assistance to come through. Get that application processed and get that paid to the landlord, which then hopefully resolves the eviction case.
Great. Okay. And then finally, What should I do if I get served with an eviction warrant, but my landlord tells me that they will still work with me?
Uh, Go ahead and file the answer, just to preserve your rights. But, that's great. Make sure that you're continuing to stay in contact with your landlord. For a lot of the rent assistance programs, in fact, all of them, the landlord needs to be willing to accept that assistance and work with you. So that's great if they're willing to work with you. But just make sure that you still file an answer and preserve your rights and go through the court process to get yourself those protections and that time to have everything kind of hopefully come together.
Great. I think that's all of the questions we have. Thank you so much.
Well, thank you. Thank you everyone for joining us this afternoon for this presentation about the eviction process in Georgia. You can contact Atlanta Legal Aid if you're in Clayton, Cobb, DeKalb, Fulton, or Gwinnett. If you are outside, if you're in Georgia, but not in those 5 counties, you can contact Georgia Legal Services. As Sally said, those numbers are in the chat. And have a wonderful day, everybody. Stay dry.